Welcome back to one more session. Today in this session I am going to explain about doctrine of privity of contract. This principle has been adopted from an old English case, Doctrine versus Pule, 1677 case. In this case, it was held that although the plaintiff was not a party to the contract, was entitled to get claim from the defendant. So it will comes under consideration to privity of contract. So in this case, the court held that the non-party to the contract can entitle. But this decision was changed in 1861 in the case of Twaddle versus Atkinson. States that a contract cannot enforced by a person who is not a party to it. From that case, the doctrine of privity of contract was established as a stranger to contract cannot sue. Which means a contract cannot impose obligations or give rights to anyone who is not a party to it. It is based on idea that only parties to a contract can be sued or sue under it. Doctrine of privity of contract in India. The position of doctrine of privity of contract in India. In India also, there has been a great divergence of opinion in the court as to how far a stranger to a contract can enforce it. Though the Indian Contract Act has no provision either for or against this rule. The English law decision in Twaddle versus Atkinson is equally applicable in India. The Supreme Court of India has expressed itself in favor of the rule in Twaddle versus Atkinson in the case of MC Chaco versus State Bank of Travancore. So finally, the conclusion is that doctrine of privity of contract means a stranger who is not part of the contract cannot enforce, or a stranger to contract cannot sue. Thank you.